March 19th Land Use Advisory Committee meeting to order. We got a lot of information to cover today to get ready for our system statement hearing, so we'll just be acknowledging the Dakota Land, Water, People Acknowledgement. Everyone's had a chance to look at the agenda. Any changes, modifications? No? All right, so that stands. I am looking for an approval of January 15th Land Use Advisory Committee meeting minutes. Motion? Second?
Second.
Second. All right, any discussion? All those in favor, please signify by aye.
Aye.
All those opposed? Motion passes. All right, and we will hand it over to Dave. He is attorney with Lockridge, Grindle, Noun.
Good enough, okay. Thank you, Chair.
And after you make your introduction, we'll go around and introduce ourselves, so that way everyone has a chance to at least say who they are, cities. This one's gonna be more of an informal conversation directly with Dave, but next month's meeting is gonna be very formal. Everything's gonna be through the chair, so get your informalities out today. Yes, Jerry.
Dave, are you an attorney for the Met Council or
Lueck.
for LUAC?
Yeah.
Okay.
Looks like you got to the third bullet point of my introduction.
I'd like to be ahead of everything.
No, that's good. So I'm David Zoll, I'm a partner at Lockridge, Grindle, Now, and by way of background, our firm has represented the Metropolitan Council on a variety of matters going back several decades, and I'm now at the point of my career where I was putting this together and realized I have represented the Met Council in litigation matters going back at least 2 decades. And we've had the honor of working with the council on a wide variety of matters. For purposes of today and 3 weeks from now, when we have the hearing on the system statement on April 9th, I will be representing the LUAC committee. The reason for that is it will be a matter where you have Forest Lake raising their objections, Metropolitan Council explaining their views on the objections, and they'll be represented by folks from the Office of General Counsel, and in that circumstance it made sense to have LUAC have its own counsel for the purposes of that meeting. But I'll stop there, just a short preview. I'm going to focus today, just touch on the background of what's raised in Forest Lake's objections, but really the focus will be on what to anticipate for that hearing on April 9th, and then answer any questions that you all may have, but I'll pause there so we can do introductions.
Thank you. We'll start with Heather.
Heather Worthington. I represent St. Paul, and I'm a former economic development person.
I'm Dan Rowe, I'm the mayor of Hillsville, I represent that district on the loop.
Bill Durowski, Dakota County Commissioner.
Noah Keller, I represent Minneapolis, work for Twin Cities Habitat for Humanity.
Mike Chon, Ramsey County Commissioner.
Kathy Mokel, represent Shakopee and Scott County.
Lana Doolin, City Council for St. Anthony Village.
Joe Brunner, I'm a Watertown Township Supervisor from Carver County.
I'm Robert Gliski, representing the other half of Minneapolis.
All right.
We've met, I'm Sandy Dingle, I'm the recording secretary for LUAC and a former honor. Just like to give it our time.
I'm Patrick Boyle, and I'm actually a second rep in local planning assistance. My manager, Angela Torres, is going to be testifying, so determined that that's a conflict so for this training, so I'm sitting in her place. Normally, the director, Elizabeth Barajas of Community Development, would be here, but she's on vacation, so I'm getting the extra pay today.
Oh, all right. Well, good, thank you. And I'll just launch in to kind of the background of what to expect. And if you have questions, just interrupt. You don't have to save them to the end. At least that's my preference. So just background on the process. And this is probably familiar, maybe, depending upon how long you've been involved in the planning process. But as you know, the council issues system statements for municipalities, which provide the basis for the preparation of their comprehensive plans. And the statute provides that the municipalities that receive the system statements can raise objections to those. They have a 60-day window after receiving the system statement to raise their objections and to request amendments to the system statement. And that must be done by passing a resolution of the city council, and they have to identify specific amendments that they're requesting. Forest Lake has done that. They passed a resolution objecting to 3 aspects, and I'll discuss those, of their system statement, have identified specific amendments that they would like to see, and provided that to the council within 60 days. That triggers a hearing requirement, which is what will be happening in 3 weeks. If you look at the statute, you would see that hearing is supposed to happen within 60 days. We're outside of that 60-day window, but the statute also provides that can be extended by agreement of the city and that council, and those 2 parties agreed to extend it to April 9th. Otherwise, with the timing of when these statements are issued in 60 days puts it like the first week of January, and no one, I think, was particularly excited about that timing. The hearing is conducted to address specific objections and the proposed amendments from Forest Lake. It's not intended to be, a broad airing of grievances. It's focused on those particular issues, and following the hearing, this committee will prepare findings of fact, conclusions of law, and then recommendations of how to respond to the objections. Basically, the recommendations boil down to, I guess you have 3 options. One is to essentially deny the objections and to not make amendments to the system statement. You could adopt the amendments proposed by the city of Forest Lake, or something in between there. Maybe the amendments that they propose go further than the committee thinks is advisable, and you want to find some middle ground. Those are the options, but ultimately, those recommendations go to the council as a whole that makes the final decision on whether to adopt those or not. I say final decision, I think they could appeal it to the Court of Appeals, but I think that's relatively unlikely that would happen. So I'll discuss the procedures for the hearing. First, give you a brief background on Forest Lake's objections. It's not my role to offer any opinions on these. So what I'm going to tell you is basically what you can see from reading the resolution that the City Council passed. The first objection relates to the designation as a suburban edge community. Previously, Forest Lake had been designated as emerging suburban community. This affects their density requirements. And their objections, as I understand them, don't seek to change their designation, but rather they are asking for certain exemptions to the way that the gross developable area is calculated to be factored into the system statement. Basically, they want the system statement to say that public roadway right-of-ways and publicly owned properties are excluded from the gross area that is used to determine developable area to calculate their density requirements. So if you're into math, they want to reduce the denominator to get to their density requirements.
Mr. Chair, will you explain to me exactly what suburban edge means? Now, I've looked it up and everything else, and I've asked a couple people and you get different opinions. Could you explain?
This is one where I may turn to you.
Chair and Mr. Brunner, in the development of Imagine 2050, there was a number of community designations developed, one being urban core and urban communities, suburban and suburban edge. And the most intensive piece in the center of the region being that urban core, and then the rural areas on the very outside. And so suburban edge is that sort of last urbanized, sewered part of MUSA portion of the metro. So in the development of Imagine 2050, it was determined that new net development needed to be equal to or exceed 3.5 units per acre for new development that accommodated new growth. Not the things that are existing, things that are on the ground already, but just new growth as the cities are developing a plan to show that new growth meeting that density.
Okay.
Community-wide, that doesn't mean individual developments could be less or more, they could, in fact, we expect them to be twin homes or maybe apartment buildings or higher, and single family might be a little lower than 3.5, but that overall set, so suburban edge communities also share sort of common characteristics, one of them being that there is agricultural areas that are being turned over to suburbanization, things like that, so.
Do cities have anything to say about their classification like that? Or is it just the Met Council goes, that's that?
It's very similar to the designations that were created under Thrive in the year 2014, 15, 16, or 2012 through 13. And it's the broad kind of context or comment is that there's expectations for density, for at least this topic of residential density with this Forest Lake example, to where we have minimums we've determined that help pay for regional infrastructure, namely sanitary sewer. And so so it's been at least 15 years that we've been talking about these types of density levels for these kind of emerging suburban edge, or the communities on sort of that developing edge.
Okay.
And there was input community ability, and there was input during the Thrive in 2012, and there was input to Imagine 2050 and 2023 and 2024 as we were developing it, and then adopted it a little over a year ago.
Okay, thank you.
Yeah, go ahead, Lana.
So, you used the term emerging, so they are currently classified as emerging suburban edge versus suburban edge. Is there any distinction in that emerging aspect, like a duration of time or?
This is another one where I know you have the expertise on exactly what the difference is, and the only thing that I would note, going back to Mr. Bruner's question too, is here, Forest Lake, I guess to the question of, do cities have a say in this? You know, if Forest Lake objected to their designation as suburban edge, that would be the type of objection that they could bring, and the amendment that they would ask for in the system statement would be, we think we qualify as emerging suburban as opposed to suburban edge community. But that's not what they did. They specifically say they're not objecting to the suburban edge community designation, but they want certain exceptions to how the density is calculated folded into their system statement. In terms of the exact distinction between emerging suburban and suburban edge, again, I'll let Patrick correct whatever gross misstatements I make here. But the I think emerging suburban would be the communities, I mean, just think of it, the next ring out, that don't have the full MUSA connections and aren't quite as developed and are, I guess, one way to think of it is they are emerging suburban communities, or depending upon your views of how growth happens, the suburban edge is increasingly moving into those communities. You know, they're on the edge. Is that reasonably close?
Yeah, no, I think it is. And again, as I'm defer to the expertise, as I look through the Forest Lake document, yeah, they're not really contesting the 3.5 units per acre. It's more of how we measure it, which is really an implementation piece and less of a broad policy piece.
And I did want to clarify too that, as I understand it, the emerging suburban was a designation under the Thrive planning scheme, and that's what their designation was at that point. So I suppose one could argue that emerging suburban and suburban edge are the same thing, just a different name for it essentially.
Thank you. Mr. Chair, that's, yes. I would say that's exactly right.
So right now in the new scheme, there's no emerging suburban. Suburban edge is the the outermost served by new.
Imagine 2050 simplified where Thrive was, I think a little bit, and it's a little clearer, but in comparing the two, it's confusing.
And we definitely have a role as LUAC in that whole process of coming up with those designations.
Go ahead, Heather.
Kind of a technical question, and I'm fine if you don't have the information at hand. Do you know how much of Forest Lake is on sewer currently? So their zoning ordinance reads, minimum buildable lot size is 7,500 square feet for detached single-family lots without public sewer require at least 1 acre of contiguous buildable land. Residential PUDs generally require a minimum total area of 7.5 acres. So I'm curious about like what is the cumulative impact of removing those non-buildable areas, in terms of the math, if you will.
And one thing I want to be careful of too is not getting too far into kind of the merits of what they're raising or the facts relating to it.
Okay.
Because the purpose of today's meeting, in part because the parties aren't here, Forest Lake isn't presenting as part of this, nor is the council, is, this shouldn't be a fact gathering type of conversation because, if you happen to know.
I don't know, and it's not my sector, so I'm not really sure if you look at this.
Yeah, but I do want to be careful since Forest Lake and the council don't have the opportunity to present testimony or evidence today, that we're not getting into grounds where we're exploring the factual basis underlying their positions other than the resolution that they passed.
And our opportunity to do that would be at the hearing.
Yes.
Thank you.
Yep. Yeah. And once we get through kind of an overview of their objections, we'll talk about the hearing process and what to expect there. The next category of objections relate to the households forecast for 2030, 2040, and 2050. As laid out in their resolution, Forest Lake believes that the council's prediction for growth over the next, whatever that is, 24 years, is too low. And they explain some of the basis for that in their objections. And I imagine at the hearing in 3 weeks, you'll hear more from Forest Lake about why they think the projections are too low, and you'll also hear from the council, I assume, regarding why they believe that the projections are accurate. And then for that particular objection, Forest Lake identifies specific growth numbers that they think should be included in the system statement. So they have proposed alternative growth projections, and then the job for this committee will be hearing the evidence that you hear in 3 weeks, making a determination. Do you stick with the council's projections, Forest Lake's projections, or is there some other number that the evidence supports on those? The final objection they raise is related to the allocation of affordable housing units for Forest Lake, though I do not anticipate that this will be a significant issue in 3 weeks because the Forest Lake resolution says specifically, City of Forest Lake objects to its system statement affordable housing allocation and the classification bands, and here's the important part, but request no Met Council amendment at this time. So they're saying that they object to the allocations, they're not requesting an amendment, they're not proposing an amendment, and because the charge for this committee under the statute is to address the proposed amendments, I don't anticipate that there's going to be much on that issue. It strikes me as they want to make their objection known.
Thank you. Is it best for us to remain neutral and not do a lot of research on this at this point and wait for the hearing and try to go in with an open mind, or?
Would you like to talk on the burden of proof?
Yeah, I mean, yeah, let's, this is a good transition to what to expect for the hearing. And hopefully I can give you some guidance on that point. I think, let's start here. The city of Forest Lake has the burden of proof in this matter. So this isn't a court, but if they were going to court, they have the burden of establishing that their proposed amendments should be made. And what they need to do is come into that hearing with evidence and testimony on those points that when you consider everything you've heard, convinces you that something should change. And if it's a tie, because they have the burden of proof, it stays the way it is the way I would think of it. In terms of research.
May I ask, when you say a tie, meaning what, a voting tie?
No, I mean a tie in your mind. So if,
Yeah.
I'm trying to think of it, because what they're proposing are amendments to the system plan, it's a little bit different, but let's take it out of this context and think of it, if you were jurors in litigation and the party has a burden of proof to establish their position by preponderance of the evidence, which just means it's more likely than not that what they're asking is correct. So let's think of it here. Is it more likely than not that their system statement should be amended? And if at the end of the day, everything you hear means it's exactly as likely that it should be amended or not amended, they haven't met their burden. But if it's just a smidgen more likely, they've met their burden. It's tough to apply a rigid burden of proof in that sense in what is also a policy type decision, right? But that's what I mean by a tie. In terms of a tie amongst the committee, I guess we fall back to Robert's rules. If there's a motion to grant the objections and adopt the amendments and it ends in a tie, that motion hasn't carried. Then there's an alternative motion going the other way, and if that ties, then by golly, we're gonna have to figure out how to write a report that ends up with there being no recommendation to the council on what you do. So two different types of ties. In terms of research in advance, I'm gonna start with the very end product of what this committee does and then come back to directly answer your question. The end result is a set of findings of fact, conclusions of law, and recommendation. And the findings of fact is based on the testimony and evidence that you hear at that hearing on April 9th. Just like if it was in court, it's the testimony and evidence that you hear during trial. And those findings of fact have to be able to tie back to the evidence that was presented in that April 9th hearing. So you can't bring in evidence beyond what the two parties present and fold that into the findings. So in that sense, you shouldn't generate your own evidence. It's the party's obligation to bring evidence forward to you. But in the time between now and then, you will have the opportunity, if you choose, to think through what are the issues or questions you have that you want answers to. And instead of going to the internet and sorting them out, make note of those because you'll have the opportunity to ask the council or Forest Lake for additional information on those. Because those findings of facts have to tie back to what we hear on April 9th, we don't want the committee, who's the fact finder, to be bringing in their own evidence for that.
Lana, you got a question?
No, that was a really good question because it's like, when I first looked through this and thought, are they saying they don't think they're the suburban edge? Going and looking for myself, what's the difference between suburban edge and that's not something I should have done?
No, that.
Yeah, I checked Chat GPT.
Okay, don't do that.
Okay, delete.
Use other tools.
I went to the website.
But, okay, so that is, the example you give is a little bit different in my mind than researching facts, right? That is looking at, so what's the definition of a suburban edge community and what does that mean? So you have an understanding of what that term means. Do they fit that definition? Which is information that you could then use to ask informed questions. If, understanding that they're not challenging their designation, they just want these exceptions written into their system statement. But let's say they were challenging their designation, then you could ask informed questions of, okay, the definition of a suburban edge community is this. Do you agree that the city of Forest Lake meets this requirement, that they meet this requirement, and they meet this requirement? And then, so then you have the opportunity to make some informed questions. So that's kind of the research of making sure you know what questions you want to ask and have a base of knowledge for it. Researching, building permits that are issued by the city of Forest Lake over the past however many years. That's getting into more of the facts that, is where I would try to suggest you stay away from. This is going to be helpful too when I talk a little bit more about the process.
Jerry?
If Forest Lake is proposing amendments to their classification, isn't that what they're saying is we want to be reclassified from suburban edge?
I'll turn back to their own resolution. They say they object to the system statement suburban edge community classification. So they do object to that classification and request the council consider amendment memorializing the following local exemptions to the gross developable area. Right, so they're objecting to that designation, but they also have to propose what the remedy is. Right, so what would they be if they weren't suburban edge? Just not suburban anything?
Suburban or
Yeah.
more dense designation.
Yeah, so they aren't asking to change for their remedies, right? So they say, here's where we were wrong, it is something related to the classification. They have to say then what they want the council to do to fix it. And they're not asking to change their classification. They're asking for these two specific local exemptions to be specifically memorialized in their system statement. And these are things that my understanding is the planning department here at the council, as they're working through comprehensive plan and other things, may take these things into consideration for communities. And what Forest Lake is saying is we want these specifically written into our system statement. So it's the remedy that they're asking for is kind of what defines whether that we should be thinking of this as they want to change their classification. That's not what they're saying. They're saying with this classification, we want these two things specifically written into our system statement to exempt certain areas from the gross developable area.
Which,
I still, to me, they don't like the classification because they want to have amendments to it. I feel somehow it's not registering in me the difference here.
We'll have to find out what they say when they make it.
Right,
right.
That's the piece we don't have, is all their evidence to support what they're asking.
Okay.
Yeah.
All right.
Yeah.
Leave it to the mayor to know what to do.
I'm just lying with us in my hands.
Can I add?
Robert.
The designation that they're classified as the suburban edge that's the lowest density classification that they can have still as the sewer, like as part of the MUSA sewer district. So I think they understand, or they might understand, I don't want to assume, that they can't really change a designation to get lower density because they have sewer service.
Okay, I see it, okay.
Change the calculation of how
Yeah.
we
Yeah.
can figure out that it's.
we want your sewer, but not your calculation.
Yeah.
That's right.
Yeah,
Go ahead, Bill.
thank you. And as I recall, I think it was a couple of meetings ago, the definition for what's excluded on stormwater it was modified slightly. Will we have that in front of us?
We can definitely request that from Patrick, he's writing it down right now, because there was exclusions for the stormwaters
Yeah.
and certain right-of-ways.
We have
That's
kind of
what I
Already.
was thinking.
Yes.
no doubt the savvy lawyers for the council will be.
And if they get it this year, we'll want it.
That would be a question I might consider asking.
I was gonna talk about the hearing, but actually, I think it'd be helpful to talk about what happens between now and April 9th. So you have a sense of what you will have in front of you going into that meeting. Yesterday, a letter went out to Forest Lake and the council, laying out the timeline and procedures for the hearing. The first thing that will happen is on March 30th, the city of Forest Lake will submit a pre-hearing memorandum, a witness list, and an exhibit list. So they'll identify, here's our witnesses, here's any exhibits, evidence that we want to introduce, and then the pre-hearing memorandum. That pre-hearing memorandum lays out their, essentially their legal arguments. It describes what they're asking for, and what the basis for that request is. So think of it as essentially a written preview of what they're going to present on April 9th. On April 6th, so 3 days before the hearing, so Forest Lake is about 10 days before, 3 days before, the council will submit the same thing, pre-hearing brief, witness list, exhibit list. When we were working out the schedule, Chair Morales asked the good question of why are the deadlines different? And I thought that's an excellent question, but I'm used to it as a litigator, which is then what I explained, is the reason for that is the city of Forest Lake lays out its position and then the council's able to respond to it and focus its explanation, its position on the issues that are actually raised. I mean, they have, I assume, a pretty good idea based on the resolution from the city of Forest Lake as to what the arguments will be. But if you don't have the party with the burden of proof laying out their position in advance, you have to guess a little bit. And it might cause the council, if they were doing it simultaneously, to have to focus on a bunch of things that Forest Lake isn't focusing on because they didn't know. So that'll be the process. You'll have those things in front of you, an opportunity to review before the hearing. Probably the most key items will be the pre-hearing memoranda from each of the parties that lay out their positions. And in my experience, I guess writing these from where I sit as an attorney as opposed to a judge or sitting on a body like this, what I anticipate is those will be a great source for you to identify some of the questions that you're going to want to follow up on, and to be able to test some of the assumptions that you're hearing in those written materials. So it's something where if I were in your shoes, I'd probably have my pen making notes in the margin as I'm going through those about things that I'd want to follow up on, or things that Forest Lake says that I want to hear what the council says about, or points that the council raises, and I just want to ask Forest Lake, well, what about this? So I think that'll be very valuable information for you all to have. The hearing on April 9th, the process for that, each party will have the opportunity to make an opening statement of 5 minutes to lay out for you, if they do it right, a roadmap of where they're going to go, and explain in a really concise, direct manner what they're going to present and why it matters. And then the City of Forest Lake will have the opportunity to present its testimony. It may be the city attorney presenting testimony, or someone from the city planning department, or whoever else they think has relevant information. They will provide testimony. You all will have the opportunity to ask questions of them. What I would suggest as an approach is to allow the city to make its presentation, and then you can follow up with questions at the end. It's usually cleanest. But there may be times when there's just a really specific item that maybe someone misspoke or you want to clarify on. So as much as I just said, maybe hold questions until they've presented their full testimony. You also shouldn't hesitate to jump in if there's something that is crucial at that particular moment.
I'm just a country boy. That information that's gonna come out on the 6th, will I be able to understand it? Or is it, do I have to be a Philadelphia lawyer, as the saying goes, to understand it?
We'll start with a Minnesota lawyer who grew up in Iowa, hopefully is gonna understand it. So I'm not a Philadelphia lawyer. And if it's well written by the folks who are presenting it, it should be understandable and digestible. And the other advantage, or the other thing to keep in mind is you will have, before that, Forest Lakes memorandum that they'll be addressing the same issues. So what you'll see from the council's presentation is likely going to lead to different conclusions, but it's going to be a similar analysis. And this doesn't strike me as a matter that is going to get deep in the weeds on technical issues, or in really nuanced parsing of language of the statute, where I've done this, getting in arguments over the placement of a comma, or how does that affect the meaning of something. This isn't that type of issue. This, I think, is a more broad-based discussion of kind of bigger policy issues. So that's a long way of saying I'm confident you're going to understand.
Okay,
Yeah.
thank you.
Yeah.
I'll keep you to it.
Right. Now the pressure's on other folks to not make me a liar.
So I have a question for you. So something gets issued, we have the ability to look at it, and then, so like on March 30th, the memorandum, the witness exhibit, and April 6th happens. In that duration of time, if we look at our material and we have questions about something in that, are we allowed, or should we ask questions of someone? Or we just keep our questions to ourselves?
So with open meeting requirements, right, you all shouldn't talk to each other. But don't set up a group chat and ask the questions. I know you all know that, but I feel an obligation to say it. If there's technical questions, and I don't know how your committee always functions, but if you have technical questions, or if you want some Met Council data on an issue, I would think reaching out to Lisa perhaps, would that be where they would turn?
Yeah.
Yeah.
Well, she's not here, she's testifying, right?
Right, so can
No,
we?
that's
Or no,
Angela.
Angela doesn't have to be the one testifying, so yeah, it should be Lisa, but we'll clarify whether it's Lisa or somebody else and get that information out to everybody.
Yeah, if you want to just send it to me, if you have a question, and then I can go from there.
And don't CC everybody, just do it directly to Sandy.
Yeah.
Thank
Yeah, and then Sandy, if you get those, if you just include, if it's Lisa to reach out to, but include me as well.
Sure.
And then we can make sure that we're handling these things appropriately.
So, I was gonna say, it's fair to say though that once the information from Forest Lake comes out on the 30th, and we get it, the Met Council response on the 6th is gonna be trying to address what they've, and maybe our questions would be answered by the Met Council's response on the 6th. So I guess it just depends on what the question is.
And then the same thing between the 6th and the 9th then,
Right. Yeah,
questions.
After the 6th, once you receive the Met Council's information, I would just write down the questions on the margins to ask those, because the only person you're gonna be asking those questions to is gonna be on the 9th, and you don't want to be giving the question ahead of time before we're in the meeting.
Gotcha, yep, okay. After the hearing and after the process here, is there a path for like the city to appeal?
So two steps for them. After the committee issues its recommendations, it goes to the council for the council to decide ultimately what to do. And the city can make its argument before the council in terms of the approach. And then, with any final governmental action, they could pursue an appeal with the Court of Appeals.
Thank you.
All right, so each party has 60 minutes to present their case. We told them that 60 minutes includes interruption for questions. Take back what I said, don't hold it for the end. If you have a question, ask it. And the thing I would say about the 60 minutes, we told them 60 minutes. I would try as best as you can to hold that time. But the committee can extend it also, right? So if there's a lot of thoughtful discussion going on and questions being asked and the city of Forest Lake is an hour into their presentation, you don't have to cut it off. You can choose to let them extend it. But it's also the reason I wanted to put that in there so that they can plan and know that the expectation is that they have a limited period of time and they got to be concise and direct in their presentation. It's not like they get to sit here for 4 hours and make their case.
Go ahead, Bill.
So as chair, you run the hearing?
Yes, sir.
Okay.
Yep, Forest Lake and Met Council will have to go through me. There will be no cross-examination of each other. We're the only ones that get to ask either Met Council or Forest Lake questions, and that's it.
Thank you, Judge.
So as a matter of process, a decision to extend might be something that would be handled like through a motion and a vote of the committee, or a decision by the chair that could be appealable, I suppose, under rules? Or how would that mechanically happen?
Right. What I anticipated, on the assumption that you all trust the chair's judgment on such things, is, it may be less of a formal extension of 5 minutes, but, if it gets to be 61 minutes and they're kind of wrapping up, that you just let it flow, and it's an extension by not cutting off. But certainly, I think it would also be appropriate if, it's stretching on further than some of you think it ought to. You can ask a question of the chair, and then there can be a discussion amongst the committee as to whether to continue that conversation.
Then the other part of that would be, I imagine, from a fairness point of view, if the Forest Lake has an hour and they use 61 minutes, and then the Met Council's, at that point of their hour, and we give them another 30 minutes, Forest Lake may ask for some more time after that, or so to try to have a balance there, depending on what they're, where they feel they're at.
Right, yeah, and that's one where you're just gonna have to be fluid and address that in the moment.
Yeah.
And, I mean, the key is fairness, and it may very well be that if that happens, Forest Lake feels like they've been heard,
Exactly.
and don't ask for any more time. It's rare that two parties in a matter take precisely the same amount of time. The final step after each side has presented their witnesses and their exhibits and evidence is they each have the opportunity to make a closing statement, which could also be the opportunity, if Forest Lake feels like they have something more to say, they could make the closing statement. I did look back at the transcript from the last time the committee had one of these hearings, which was 20 years ago. And in that circumstance, both parties actually waived the closing arguments in advance. They decided that they didn't need them. The reason for that is the next thing I'm going to talk about, which is in the schedule that we sent out, and it's noted on the flow chart. When I had a conversation with Lisa about the flow chart, she had it printed on like legal paper, which explained why she was able to read it. And I was struggling like this.
I'm the oldest one in the room, I can read it.
10 days after the hearing, the parties submit proposed findings, conclusions, and recommendations. That basically, in a sense, serves as their closing argument. And it will be basically what they propose, the committee adopts as their final decision in this matter. So they will lay out the specific findings of fact based on the evidence, and they'll cite to, testimony of city planning director or whatever it might be. So they lay out the facts that they think you should adopt, they will lay out the conclusions, and then the recommendation that they think you should make to the council. Those happen simultaneously. There's no need to do those in a stepwise basis. They both have heard all the evidence. Those come in, and then comes the fun part, the hard work. I'm not sure what the right description is, but that's what ultimately leads to the final step in this process for the committee, which is to take all the evidence you heard, take the submissions from the parties, including those proposed findings, and ultimately develop the findings of fact, conclusions, and recommendation from this committee. And there will be a meeting set. I think you also need to set the date for that meeting. It has to be within 30 days after April 9th, where you will meet and make the decision on the proposed findings of fact and conclusions of law. If you're wondering procedurally, and this would be a good thing to be wondering, how on earth are you all gonna meet and draft proposed findings, conclusions, and recommendations? Because editing by committee is tough. Writing by committee is even harder. What will happen is staff, and then I will work with them, will prepare draft proposed findings, conclusions, and recommendations for you. And we will endeavor to not tip one way or the other in terms of the ultimate outcome. So if we're thinking about the recommendations, I would think of it as, for those of you that serve on city councils or county boards, you'll get proposed resolutions from staff that say, on question 3, A, B, or C, depending upon what the decision is, by the policymakers of which way to go. And I would anticipate we'd have something similar. The facts we'll basically try to write as objectively as we can using what the parties submit. The conclusions of law will have to think about how exactly that comes together, because that's kind of a key thing that leads to the recommendations. But the recommendations would ultimately be the decision that you make, and so I anticipate it would be presented to you as on the issue of incorporating the exemptions to the buildable area requirements. Option A, reject the objection and do not, incorporate the amendments. Option B, incorporate the amendments proposed by Forest Lake, and then you'll make the decision and be able to. The goal is to give you something where someone can articulate a motion at the end of that meeting that gives staff and me clear direction on how to write the final findings and conclusions and recommendation that reflect what this body decided.
So on that day, we vote and decide.
Yes.
And then you have 30 days, you'll write up.
Well, April 9th, we hear it, then within 10 days
10
is when
days.
we get the proposal back from Forest Lake, the council, then at our next LUAC meeting is when we get everything presented to us with the options of should we accept, should we reject, or should we do a custom one for what they presented. It won't be happening on the 9th.
Sorry, when you said on that day, I was jumping ahead to the meeting after the 9th, is where the vote and decision making happens.
So make sure we remember what we heard on that day.
The proposed findings will help with that. And there will be, by the way, a court reporter preparing a transcript of the proceedings too. So if there's something that you don't precisely remember, there'll be a transcript you can refer back to.
Go ahead, ma'am.
Yeah, Mr. Chair, I won't be here for the hearing on April 9th, since I will be out of the area here. Will I still be able to vote at that next meeting then, after we get those written items?
Yes, and that's another reason for having the court reporter preparing the transcript is then you will have access to all the same information as all the other members of the committee. You will not have seen the individuals testifying, but you'll be able to read the testimony and see the exhibits they introduce, and therefore be able to participate in the deliberations.
Okay, however, will it be recorded though on April 9th?
I think the plan
There will be
is,
a recording, we checked into the streaming, and I believe, we'll have it recorded. I don't think that we're streaming out per se for somebody to watch. I don't know if that's something you discussed. We have that capability, but I don't know if that's something.
we didn't discuss that, and I don't feel strongly one way or the other. If the committee's meetings are typically streamed, you could certainly choose to stream that hearing, and then it's, anybody can see it. There's no obligation to do so, but there's no prohibition on doing it. That would be a decision for the committee to make as to whether they want to provide for streaming for that hearing.
But the recording could be made available to anyone who was absent from the night.
Yes.
Thank you.
And
Go ahead, Lana.
you'll prepare the recommendation and then it's just the next regular LUAC meeting where we'll make that decision? Or
So
is-
it won't be a regular LUAC meeting, because the one we have regularly scheduled for May is the third Thursday. And since we have to do it 30 days after April 9th, that was gonna be a conversation we're gonna have about May 7th.
Okay.
Because that would be within 30 days. Anybody, we'll ask this committee, either way for the May 7th, but we'll also send an email. There really isn't much of an option, it has to be that day. It doesn't work the week after.
Works for me for now.
May 7th?
May 7th. Then I did also have one more question for the April 9th one.
Well, go ahead, let me mention one thing about April 9th too. The statute does also require, in addition to the parties, if there are members of the public that want to speak to it, it's a public hearing, they have the opportunity to speak. And it would be, as happens at any city council or county commission meeting. But I suggest limit time, whether it's 3 minutes, 5 minutes. And you can also ask questions of, if there's a knowledgeable member of the public that's speaking on this and you want the perspective, you can ask them questions about it. But I just wanted to note that too, that in addition to the parties, and I would suggest after they've presented their testimony, if the parties are going to do closing arguments, I might hear from the public and then do closing arguments. But, and it may be that there's nobody that wants to testify. Sorry, that was second to last thing. In terms of my role on the 9th, I anticipate that I will be sitting quietly for most of it. As the chair mentioned, he will be running the meeting. Thank you for waiving formality. For this meeting, it's easier, but for that, everything will go through the chair. My role, if there's a procedural question that comes up, I'll be available to answer those, but I'm not participating in the hearing. I'm there to observe and then offer advice on any procedural questions that come up. Sorry,
Thank you, Dave.
I deferred or delayed you.
So for April 9th, if you looked at the letter that went out, we did mention the time to be determined, right? If everyone's okay with it, I would like to move it a little bit earlier, so that way we don't run out of time. If things end up going longer, if people have commitments at 7, 8 o'clock at night, looking to either move it closer to 2, 3, if anybody has any objections, or earlier.
I'd like to move it earlier. 11 o'clock, noon, somewhere in there. I have a long way to drive, I guess, so.
Everybody else here?
I think mine would be fresher too, earlier in the day, to absorb all that information that's gonna be thrown at me here.
This is the 9th, right?
The 9th of April,
Oh,
yes.
okay. Yeah, I'll still be out.
Okay.
It can be any time for me.
I'm out, so.
Heather,
That's fine, earlier is fine.
11 works for you,
Uh,
or did you want 2 o'clock?
I think afternoon would be great.
2?
Noon or later, yeah,
Same here.
that'd be easier.
So 2 o'clock works for you? Dan?
Should be right.
I can make 2.
Noah?
2 work?
I'm good.
Lana?
Yep.
We know you, Jerry. Robert, 2? All right, so everyone's in favor of doing it at 2 o'clock for April 9th?
Yep.
Those that can be here? Okay. Go ahead and include that and send that out to Forest Lake with the updated time.
I guess the only thing that I would add on that, we did in the letter say 4 o'clock, they may move earlier, we'll advise them right away. If, you know, if they respond that there's a reason that they absolutely can't do it before 2:30, we'll let you know and figure it out from there. But we will inform them that it is 2 o'clock, and I'm guessing it will work.
Similarly on May 7th, we do the same thing.
May 7th earlier?
Earlier that day, if that's possible.
Anybody here opposed to meeting earlier on May 7th?
Sounds
Well-
good to me.
All right. Looks good for everybody, May 7th?
Yeah.
2
My
p.m.?
afternoon's open.
And that would be held in chambers too, at both the
chambers.
hearing and
Oh.
the May 7th meeting,
So both the 9th and 7th.
because we have another meeting.
So 2 o'clock again?
Thank you.
We'll make sure to send out the corrected invites for both of those. Any other questions for Dave?
Will all the materials that we get have to be provided to us in hard copy form, or can we get them electronically, or?
That was gonna be the last question.
Yeah.
The option is up to you. You know, when anything is printed out, the cost is gonna be divided amongst Med Council, Forest Lake, attorneys, everything else. I'm a digital person, so I want mine digital. I think we can send an email to the council members what their preference is, if you want it paper or you want it digital. And then we can send it out that way for those that aren't here.
The biggest factor potentially could be on the stuff we get on the 6th. When do the members get it before the 9th, if it's in hard copy form? There's
Right.
kind of a quick turnaround that has to happen there. That was what's coming to my mind in that regard, but I'm totally good with electronic.
And everything's coming from the parties in electronic format too, so they're, you know, it's not like someone's gonna have to scan, the materials to get them out to you.
Go ahead, Noah.
2 quick questions. First is, are we able to ask for a clearer definition of reasonably width roadways? Or I think that's what it was referred to in the first resolution. Land areas required for reasonably sized local roadways. Is there a definition of reasonably sized local roadways, or could we ask for?
I bet they have to provide that.
50 to 100 feet.
Depends on where you live. If you're in
Right.
downtown, reasonably sized is
Is
10
that-
feet. If you're in Watertown, 100.
With it in.
But yeah, the burden will be on the city to provide that.
Okay.
So is that similar to the question I asked about sewerage? In terms of the sort of technical detail of how many lots are served by sewer?
That would probably tie back to doing the research for the city, if that's not something they're providing, I would think, Dave.
I'm asking, when should I ask that question?
Right, so, on Noah's question, that's one that I would, if I were in your shoes, I'd just put to the city of Forest Lake. When you talk about a reasonable, reasonably sized local roadway, what do you mean by that? What is your definition of a reasonably sized local roadway, and get their view on it? You can ultimately reach a different conclusion than that, in terms of what's reasonably sized and, whether that should be context dependent, depending upon the locality, but that's the type of thing you put to them. On the question of,
Finding out how much Forest Lake is sewer,
Yeah.
not sewer.
So it is in their system statement, because they
Right.
have part of their territory is the rural designation or whatever it is. And there's a map of the city limits
Right,
with
right.
how much is how much.
And Mayor, that's getting to this question of, can I know that going into this conversation? I mean, that is, I'm gonna use a word, discoverable to
Right.
me, right?
Anybody can ask me that question anytime, but I
Right.
defer to what
Right.
is protocol here.
And I did, and
yeah.
so I'm just coming back to it to say, when is the right time to ask that question?
So a couple things, to the extent that it's laid out in the system statement, that was included in the packet for this meeting. So certainly you can look at the system statement in advance, in particular because that's what they're asking to have amended, is that document. So anything that's in there, you can go ahead and research. I think your question where it maybe becomes relevant in this, it'd be appropriate to ask of Forest Lake because I think what that gets at is how much of your city is affected by this? How much can be developed? You're saying this creates a problem for you on development. How significant of a difference is this between the minimum lot size for sewered properties and non-sewer served properties? I think that would be the type of thing that I would be asking of Forest Lake.
Thank you.
Sandy did mention the system statement is attached to the council agenda online.
Got it, thank you.
Bill?
I don't know if I should ask the question today or if the info should be supplied. But when we had the housing collapse, the Met Council adjusted numbers.
Yep.
I don't know if it was for everyone. Do we have historically, the number of times the Met Council adjusts numbers? Because we're so far out to the future, should I be asking that today or wait?
I anticipate that is something you will hear about on April 9th or April 6th.
Okay,
Um,
I'm good.
yeah. Because I think what you're asking is questions regarding reliability of the council's forecast.
Right.
And that is the type of evidence that they're going to be presenting, is why they believe, I should say, if I were representing them at this proceeding in defending these numbers, I would be explaining to you why I have confidence that these numbers are reliable. And if I were in their shoes representing them, and I'm not, I would anticipate questions like that. Because it's a question that occurs to me too, is, unexpected things happen in terms of development. How's that accounted for? Yeah, I expect that you would probably hear about that.
Okay.
Go
This is purely a question of curiosity. Was the hearing you referred to earlier 20 years ago, was that Lake Elmo?
Yes.
Thank you.
I have a question in addition to Bill's, is that, those adjustments to those statements, do those happen with each system statement? Or do we wait until that next term of 10 years, or do we do it in the middle? I mean, because that's something that I think we should know.
Can you repeat that? I was jotting.
My question was, with regard to those adjustments and numbers, do we do those in the middle of one of those years, or do we wait until that next planning period?
To the system statement.
Yeah, to this, and it's just an adjustment to the system statement.
The forecast.
Yeah, the
Yes,
forecasting,
yeah.
those adjustments.
Cities in between plans.
Yes. This is not their only bite at the apple.
Got
Got
There are plenty of cities who complained to me, and they said they didn't want to go through the hearing process, and they wanted to do some research, do some outreach, and do their own, market research for things, and then they were gonna come at me with these issues, requests for lower or raise or whatever during the decennial review process, which is fine. That's happened the last round, the round before. There are adjustments to official forecasts in the amendment process, which is any time in the 10 years.
Okay.
And you'll probably hear that too, next, or the 9th.
Just in terms of roles, you're this committee's attorney?
Yes.
Not the Met Council's attorney, correct?
Correct.
Okay, so Met Council will have somebody making their case.
Correct.
As part of their efforts, as will Forest Lake.
Yes,
You're
yeah, someone
providing
from the
advice to
Office of
us.
General Counsel will be appearing before the committee for purposes to advance their case.
Got it, okay.
Protocol in terms of interacting with the chair, since it's a quasi judicial hearing. So would you like us to raise our hand and be acknowledged, Chair Morales,
Raise your
et
hand.
cetera, et cetera? Is that how you want to do it? Okay.
You don't have to do the whole chair, but.
It's on the record. May as well.
Will you be wearing a robe?
Yes.
Who's got the powdered wig I can borrow?
You can have a special chair.
And crimson robes, of course.
I think you need a really big gavel for this. Yes. A Thor type gavel.
There you go.
I don't have a black robe, but I've got a burgundy trench coat. I'll bring that.
Should be fun.
Oh,
Go ahead, Jared.
Are there other cities waiting to see what happens here before they do anything?
No, there was only 4 cities that either, 3 of them went to the Office of Appeals and only Forest Lake came to us.
The time period
It's
for
over,
any more
yeah.
is done.
more is done,
Yeah.
yeah. But to answer your question, probably. You know, they're always watching. Yeah.
Wait 10 years and then.
There you go.
Yeah, I didn't mention that in the discussion of the process, but the cities do have an option. They can come to LUAC and present their case, or they can go to
It's Court of Administrative.
the Court of Administrative Hearings or Appeals. They changed the name. It was the Office of Administrative Hearings. And I'm locked in my ways. That's how I'm always gonna refer to it. But they could go that route, and it ultimately ends up in the same place. It's either the committee makes a recommendation or an administrative law judge makes a recommendation that goes to the Met Council to make a final decision on.
Go ahead, Jared.
I got a question for Dave. What basically is the difference if they go to an administrative judge than a committee? I mean, from a lawyer's point of view, what would be, is there an advantage one way or the other, or what is?
Well, we know we're better than an administrative.
Well, that's what I think too.
It's 1%.
The main difference is 1 person you have to sway, 16 people you gotta sway.
Yeah, so why would they pick us?
Because we represent communities,
Yes.
so we're in that same ballgame.
Perception.
Yeah, sure.
What?
You all have answered better than I would. Which would be, I'm not gonna, that's a decision that they ultimately make, and they'll weigh the pros and cons of each route.
They've looked at all of our bios, Jerry.
Right.
Who's
Watch
gonna be on
every
their
meeting,
side,
watch
right,
every
exactly.
meeting.
So they know you're gonna vote one way or the other.
But there's no preemption.
I was curious, I would think mayors and city council people would be on the side of Forest Lake. I mean,
Sure.
That's a possible
Yeah.
conclusion, yeah.
so that's why.
Reasonable conclusion.
Possibly.
LUAC for it, right?
We're gonna need very much.
I'm sure lawyers always like strategies
Yeah.
because they want to win, correct?
These,
Straight down.
I will agree with that statement. Lawyers think strategically, we enjoy winning, yes.
And it's the full LUAC. I mean, there's no commissioners near that area that everybody's going to be participating, right?
Everyone that's appointed to LUAC will be part of the process. Any other questions for Dave? Alright. Then I will call this meeting to order, if there's nothing else. Sandy?
Call to order?
Close, no.
Adjourn.
Sorry.
Okay, we should do that.
A quick question, just for the minutes, my last name is Zhang, so I just noticed that it was written as Chang Zhang in the minutes. So just like to make that amendment and last name is Zhang for the minutes, to reflect the minutes.
Yep.
Yeah. Thank you.
for January 15th minutes.
Yes.
Thank you.
Well, a short
Anything
meeting, I can walk to
Wow.
the parking lot.
This meeting is adjourned.
It's light out and it is